Ms. Coger, can you hear me okay?
Yes, sir.
Thank you. All right, we're on the record in People versus Teresa Coger. This is case number 226264. We have counsel with your appearances on.
For the record, John, I call behalf of the people. Gary Deal on this code, on behalf of this code.
All right, this is set for a probation violation hearing today. Mr. Gilo, how did we want to proceed?
It's my understanding that the department would accept a plea to count 5. And then after she pleads to that count, we'll release her from probation.
Ms. Davis?
Yes, Your Honor. If she pleads guilty to count 5 of the non-technical violation, I discussed with her, we dismissed all the other counts in this. As of today, she has 112 days jail credit. She has been sentenced on her retail fraud in Grand Traverse County. So my recommendation would be to discharge her unsuccessfully with the 112 days credit for time served.
Okay, so essentially just proceed with sentencing today.
Yes, if you would like. I believe her original guidelines are 0 to 3, Your Honor.
Okay. All right, Ms. Coger, were you able to hear all of that?
Yes, sir.
Okay, is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. Ms. Coger, you understand that you do have the right to have a hearing as to whether or not you violated your probation,
Yes, sir.
and that by pleading guilty to the violation today, you're going to be giving up the right to have that hearing.
Yes, sir.
Also, by pleading guilty, you will be subjecting yourself to the maximum possible penalty on your underlying charge, which is up to 2 years. Do you understand that?
Yes, sir.
Those things in mind, how do you want to plead to the probation violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record here today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you did violate your probation?
Yes, sir.
On or about September of 2022, were you on probation here in Otsego County?
Yes, sir.
Were you aware that one of the conditions of your probation was that you were to not violate any provisions of state law?
Yes, sir.
And did you violate that by stealing items from a store in Grand Traverse County and being charged with retail fraud 2nd degree?
Yes, sir.
Thank you. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you did violate your probation as alleged at count 5. The court will accept your guilty plea. Ms. Coger, you've heard Ms. Davis is simply recommending that you be sentenced to time served and be discharged from your probation.
Yes,
You do
sir.
have the right. You do have the right to have this set for sentencing at a separate date and for an updated pre-sentence report to be created, or we can proceed with sentencing right now. Do you want to go forward with sentencing today?
Yes, sir.
Okay, Ms. Davis, other than what you've already indicated, is there anything else that you want to say in terms of sentencing?
Just that her fines and costs preserved, Your Honor.
Okay, thank you. Mr. Gilo, anything on behalf of Ms. Coger?
Not at this time.
Ms. Coger, is there anything that you wanted to say for purposes of sentencing today?
I'd just like to apologize, and I am truly sorry for everything, and that's it.
All right, I did have a chance to review your file prior to the hearing today, so I'm familiar with your original charges. I'm also familiar with your probation violation and the punishments that you're facing or have faced with regard to that. Looking at the circumstances as a whole, including the amount of time that you've served on this case and your original guidelines, I think Ms. Davis's recommendation for sentencing is appropriate, and I'm going to follow that. The court is going to sentence you to 112 days in Otsego County Jail with credit for 112 days served. The court is going to discharge you unsuccessfully from probation and preserve any outstanding fines and costs. You do have the right to appeal this sentence, and before you're released, we'll provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Ms. Davis, is there anything else that we need to address
No,
today?
thank you.
Mr. Gilo?
Nothing further. Thank you, Jay.
Ms. Koger, did you have any questions at all?
No, sir.
So the court will sign that paperwork today, and you should be released before the end of the day today, okay?
All right, thank you.
Thank you. Mr. Truce, is Mr. Renelette or Renelay present?
He is not.
Okay, we'll go on the record, People versus Renelette, case number 236505. If I could have counsel for your appearances on the record.
The record, Your Honor, my call out to people.
Thank you, Your Honor. Richard Church on behalf of Mr. Rowland.
Right. We did have a motion hearing recently in this file. Have you had any contact with Mr. Renelette?
So the court may recall at that motion hearing, I had indicated I had contact with him just prior to the motion hearing. That's the last contact that I've had with him. He has not responded to me since then.
So I'll look and see if we've had previous issues with Mr. Renelette aside from the motion hearing.
So, Your Honor, I do believe that there was one prior show cause in which he had, I believe it was actually his wife had a medical issue, and he did not appear at that time. I do believe he did appear via Zoom for that hearing, but the court ultimately, I think, did show cause him.
Mr. Rolla, do the people take any position on how the court should proceed today?
Judge, as Mr. Truce was referring to, that was from April 17th, and that was the failure to appear. The defendant was provided then the presence of evidence during his next hearing. He did so, he appeared by Zoom. And as a current matter, as of course, I'm sure you're all aware, when we had the previous motion hearing, that the defendant also did appear, and the court took notice of that and waived, had the defendant record indicate the defendant by not appearing waived his right to be present. It was the concern of the people that he wasn't going to be showing up, but in fact, now that's occurred, I would indicate for the record that with the motion to suppress being filed, the people revoked its prior offer. So in addition to requesting that the court issue a bench warrant for the defendant's failure to appear, I would indicate that any new plea agreement would merely now only involve counts 1 and 2 as a habitual second, in light of the defendant's, again, failure to appear.
All right, since this is the second failure to appear by Mr. Renelette in a row and the third overall as part of the case, the court finds it would be appropriate to issue a bench warrant for his arrest. Mr. Rolla, if you'll prepare that, the court will sign that once Mr. Renelette is arrested, brought before the court, and then proceed further with this case. Is Mr. Getter present? If you want to come right up to the podium, please. We're on the record in People versus Getter. This is case number 21-6114. The record should reflect Mr. Getter is present in the courtroom today. If I could have counsel put your appearances on.
Record, gentlemen, go back to people.
Gary Hilo on behalf of Mr. Getter.
This is the date and time set for sentencing in this matter. Mr. Getter, have you had a chance to go through the pre-sentence report and talk to Mr. Hilo about that?
Yes, sir.
Mr. Hilo, are there any additions, deletions, or corrections to that report?
None, Your Honor. Thank you.
Are there any challenges to the guidelines as scored?
No challenges.
Mr. Rowland, do the people have any additions, deletions, or corrections?
Judge, there should be a correction actually as to OB 15. It doesn't change any of the scoring at all, but in this case, we have a circumstance where people believe it should have been 5 points because although the defendant is playing possession of methamphetamine with the amount and the circumstance in which was found in a lockbox, $700, other pipes, scales, baggies, etc. 5 points should have probably appropriately been scored under OB 15.
Okay, Mr. Kilo, any response to that?
I have no objection to that, Judge.
All right, so the court will score OB 15 at 5 points. That raises the OB level to 5, but does not change the scoring guidelines, which remain at 5 to 23. Any other challenges, Mr. Rowland?
No, Your Honor, that would have been it.
Anything on behalf of the people for allocution?
Judge, this is a defendant who has 9 prior low severity felonies, of which only 4 will be accounted for under the guidelines. 18 prior misdemeanors, of which only 7 are able to be accounted for under the guidelines. 9 of his priors involved alcohol, 3 involved controlled substances. And 12, then total of those were substance abuse priors. Guidelines in this case are 5 to 23 months up to 10 years. So again, although the straddle cell can apply under the circumstances. That being the case, with the defendant's criminal activity, it should, with all of what he's done, including the matters that arose out of his criminal activity on this instance as opposed to criminally pled to. Jail time obviously is appropriate under the circumstances.
Mr. Kilo.
Well, the recommendation is the minimum here. As you can see from the evaluation of plan, my client's taking care of his situation with respect to being prescribed Lyrica and Cymbalta. He's, I believe, is going to ask support to hold in advance the recommendation due to the fact that he is caretaker, basically, who was significant in it. Thank you.
Mr. Gaddard, anything that you wanted to say today?
Yes. So we can say that shouldn't have been with this Ray Diamond in the first place. I went to school with him, hadn't seen him for years. Wants me to come help him get a motor for his Blazer. It's evolved, you know. I knew he was doing that because he had gotten arrested, I think, a month earlier. I say I don't have ties in this town whatsoever, whatever. Staying out of trouble. It's purchasing a house, which needs tons of work, a lot of work, working on it every day, daily. Fiance, she's in court today. Caregiver for her. Do a lot of things for her that she can't do. Without me, pretty much, she's probably gonna end up in a home. Just court people. Not my sake, for her sake.
Right, thank you. I did review the report, so I'm familiar with what happened in this circumstance. There's also a lot of information in the report about your past history and record, which, as you know, is not good. 13 prior jail sentences, 2 prior prison sentences, and 9 prior probation terms. So your record is significant, and of course that follows you, and it results in higher guidelines that we would normally have for an offense like this. I think you're absolutely right when you say you should have been involved with Mr. Donnan. Clearly, he was pretty heavily involved in trafficking drugs here in Otsego County, and I'm sure that you knew what he was up to and got yourself involved in that. And there's consequences for that. The guidelines are 5 to 23 months. I agree with the recommendation in terms of, I don't think your involvement here warrants a prison sentence, because I think you were a lesser player in this than Mr. Donnan was, based on the facts as I read them. But certainly given your past history and the involvement you did have, it does warrant a jail sentence. Sorry that it's going to affect your significant other. But that's a choice that you made when you got involved with Mr. Donnan in this incident. And so she's going to have, unfortunately, facing consequences based on your conduct. And that's not something that you can lay at my doorstep. That's something that you did yourself. I think a sentence in the lower third of the guidelines recognizes that your level of involvement in this incident, but also takes into account your past history. So the court finds that an appropriate sentence is 9 months in the Otsego County Jail. You do have credit for 3 days served. The court has reported that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and state cost of $68. You do have the ability to appeal this sentence. We're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request or appoint a lawyer to help you with any appeal. And Mr. Kilo, can you let me know once Mr. Getter has acknowledged receipt of those?
So we see.
Mr. Kilo, has Mr. Getter received his rights?
Pardon?
Has he received his rights?
Yes, he has, yeah.
Okay. Mr. Getter, you're a minute to the cover of the county. Next hearing at 9:15. Mr. Stimmer, he's lodged the Department of Corrections. I don't see them connected yet. But again, that's not till 9:30. So we'll take a short recess. We'll come back on the record at 9:30. Okay, there in Roscommon, if I could just have you unmute, please. Hey, Mr. Wilson, are you able to hear me
Yes, sir.
okay?
Yes, sir.
Okay, in the record in two different files, we have file number 195726, which is a probation file. Mr. Brown is representing Mr. Wilson on that one. And then we have a new file, 236578. Mr. Hilo is representing Mr. Wilson on that file. Both are up for hearing today, and both counsel are present. Mr. Wilson is present by Zoom video from Roscommon Jail. Mr. Hilo, as to the newer file, tell me where we're at with that.
Well, I discussed with Troy, the offer was to be count one and dismiss, and second. And plus count two in the enhancements. Scores out 19 to 47. And I initially talked to him. He wanted that to be refined somewhat, but Troy, it's not going to be, there's no other offers. So it's either accept the plea offer today or set it for trial.
Mr. Wilson, were you able to hear that?
Yeah. What was the guidelines?
19 to 47, Troy.
I'll accept it.
Very good.
All right, Mr. Wilson, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. First of all, Mr. Rolla, is that a correct statement of the plea offer?
It is. Dr. John Michael on behalf of the people as to case 236578 of page.
All right, thank you. Mr. Wilson, you understand that by pleading guilty, and Mr. Elo's explained to you what he believes your guidelines will be, but the statutory maximum possible penalty for that charge, which is possession of methamphetamine, is up to 10 years and or a $15,000 fine. Do you understand that?
Yes, sir.
And you understand that by pleading guilty in this file, that may result in a violation of your probation in the other file that we have for hearing today, and that you could face additional penalties for violating your probation?
Yes, Your Honor.
With all those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record here today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The date that I have for this incident is back on October 19th of 2022, so about a year ago. Does that sound like the right date?
Yes, Your Honor.
On that day, were you present here in Otsego County?
Yes, Your Honor.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes, Your Honor.
Did you know that that's what that substance was?
Yes, Your Honor.
And did you have any legal right to have it at that time?
No, Your Honor.
All right, Mr. Roller, the people satisfied with the factual basis?
People satisfied the first sufficient factual basis to accept the defendant's guilty plea as to count one, or to quote the statute as to accept the pleas and will where no threats, promises, or other inducements not placed on the record. Thank you.
Thank you, Mr. Elo, as to those issues.
I agree, Judge, that you have a factual basis as to being voluntarily given to the court for plea. And you can find that.
Thank you. Mr. Wilson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Mr. Wilson, you do have the right to have that hearing in person. And if you wanted to exercise that right, I would sign an order to have you transported here to Otsego County for purposes of that hearing. You can waive that right and we can have it by video. Do you know how you'd like to proceed?
By video.
Okay, so we'll set this matter for a sentencing hearing by Zoom, and somebody from probation and parole will be in touch with you for a pre-sentence report. As to the violation file, Mr. Brown, are you there?
Yes, Judge.
So in light of the plea, Mr. Brown, you know how we want to proceed with the probation violation, or do you need some time to talk?
I had an opportunity to speak with him yesterday, and we are going to proceed with making admissions.
Okay, are there any particular counts, Ms. Davis? that,
Your Honor, Agent Vertical stated that he pled guilty to count 2, the possession of methamphetamine of the non-technical. We would dismiss all the remaining counts of this violation. He also, thought, in light of everything that's going on, he has charges, I believe in Roscommon as well, that are pending in Crawford, to just make a jail recommendation and discharge this case with everything that he has.
Okay. Mr. Wilson, were you able to hear all of that?
Yes, Your Honor.
Did you want to plead guilty to that one violation in this case?
Yes, Your Honor.
Okay. You understand that you have the right to have a hearing as to whether or not you did violate your probation,
Yes, Your Honor.
and that by pleading guilty, you're going to be giving up that right?
Yes, Your Honor.
And that also, you could face the maximum possible penalty on your underlying charge in that case, which is failure to pay child support, which is up to 4 years. Do you understand that?
Yes, Your Honor.
With that in mind, how did you want to plead to count 2 of your probation violation, which alleges that you possess methamphetamine?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what Ms. Davis said here on the record today?
No, Your Honor.
Are you pleading guilty to violating your probation because you did violate your probation?
Yes, Your Honor.
All right, the court's going to take judicial notice of Mr. Wilson's testimony in the plea that we just took as a factual basis to establish that he was in possession of methamphetamine on or about October 9th, 2022. At that time, Mr. Wilson, were you on probation here in Otsego County?
Yes, Your Honor.
And were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances?
Yes, Your Honor.
All right, thank you. The court finds the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. Wilson did violate his probation as alleged in count 2 of the non-technical violations. The court will accept the plea. And Ms. Davis, if you can just have Mr. Brunical just add something to the PSI and the viewer file. I'll set sentencing for both files at the same time.
So no PD report, just something in the updated PSI?
Right.
Okay.
Thank you. All right, Mr. Kilo, anything further on this case, or Mr. Brown?
No, Your Honor.
Your Honor, he wanted me to move for immediate sentencing. However, given the fact that these other going to be set out for sentencing, I don't know as that's necessary, but that's up to the court.
Well, I think I need to have everything in front of me on one date, and we'll proceed with sentencing on both files at the same time.
Okay, thank you, Your Honor. I don't have anything further.
Okay. All right, Mr. Wilson, that's all for today. We're gonna go ahead and disconnect at this time.
Thank you.
Thank you.
Mr. Stimmer, are you able to hear me okay?
Yes, Your Honor.
We're on the record in People versus Stimmer, case number 216176, 226316, 226317. The record should reflect Mr. Stimmer's presence today by video from the Department of Corrections. And I can have counsel put their appearances on.
As to all files, Michael on behalf of people, thank you.
Very deal on behalf of Mr. Chair.
Mr. Gilo, how do we want to proceed today?
Well, we have an agreement that we'd ask the court to sanction 226316 FH. It's going to plead guilty to counts 1 and 3 as a hand second. Dismiss counts 2 and 4 in the third offense notice. There's restitution in that. And file number 226317. Guilty to count 1, individual 2, dismiss the third offense notice. And there's also restitution in that one. Then in 216176 FH, they are going to dismiss the charges, and you must pay restitution if any.
Thank you, Mr. Rowland.
That's correct, Judge. The only addition was that actually was an habitual fourth is being dismissed in file 226317 as opposed to an habitual third. But in either case, he's still pleading as a have to.
Okay. All right, Mr. Stimmer, were you able to hear all of that?
Yes, Your Honor.
Okay, is that how you want to proceed today?
Yes, I do.
Can you raise your right hand, please? I solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, thank you. You can lower your hand. Mr. Stimmer, you understand that in file 226316, you're going to plead guilty to one count of breaking and entering a building with the intent to commit larceny as a habitual second. Maximum possible penalty is up to 15 years. Do you understand that?
Yes, I do, Your Honor.
Also in that file, you're going to be pleading guilty to the unlawful taking or driving away of another vehicle. As a habitual second, the maximum penalty you could face would be up to 7.5 years. Do you understand that?
Yes, I do.
Finally, in file 226317, you're going to plead guilty to one charge of breaking and entering a building with the intent to commit larceny as a habitual second. Carries with it a maximum penalty of up to 15 years. Do you understand that?
Yes, I do, Your Honor.
With all of those penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I do.
Has anyone, I'm sorry, also you don't have an automatic right to appeal the plea that you're making here today. You can only ask for leave to appeal. In other words, you have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal of this plea. Do you understand that?
Yes, I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor, I was just under the understanding that everything would run concurrent with the sentence I'm already doing.
Mr. Rolla, are you aware of any potential consecutive sentencing sanctions?
I don't think so, in light of when this occurred, Judge. This offense that's occurred, alleged to have occurred on July 23rd, 2021. And I think that was before the matter that he's currently serving time on.
So, Mr. Stimmer, I don't think the court has any legal base to sentence consecutively, so your sentences would run concurrent.
Okay. That's all, Your Honor.
Okay. Has anybody promised you anything else other than what we've discussed on the record here today?
No, Your Honor.
Is it your own free choice to enter these pleas?
Yes, it is.
Are you pleading guilty to each of these charges because you are in fact guilty of each of these charges?
Yes, yes, I am, Your Honor.
Okay, so starting with file number 226316. The information I have, well, actually, both of these incidents occurred on or about the same time, July of 2021, July 23rd. Is that the correct time frame?
Yes, it is.
All right. And I know that we've taken some testimony from you already as to at least a couple of these charges, but with regard to the shop at 1571 South Town Line, did you enter into that?
Yes, I did.
Shop? Okay. And how did you get into that shop?
Through the big garage door.
Okay.
There was a window in it.
All right. What did you do to the window to get into the shop?
It just popped out. It didn't break. It's like plexiglass or something. I just popped it out.
Okay. And then you let yourself into that shop?
Yes, I did.
And did you take a vehicle that was located in there, a 2006 Pontiac G6?
I got the keys from in there. The vehicle was outside.
Okay. So you got the keys from in the shop, and then did you take that Pontiac vehicle and drive that from that location?
Yes, yes, I did, Your Honor.
Did you have any permission to take that vehicle at that time?
No, no, I didn't.
And then did you also, okay, this was on Town Line Road here in Otsego County, is that correct?
Yes,
All right. And then did you also enter into a garage on Van Tile Road here in Otsego County?
yes, Your Honor.
All right, and I think, did you take some property out of that, some cans, I believe we talked about the last time?
Yes, Your Honor.
Did you have any permission to remove those items from that garage?
No, I didn't.
Mr. Rolla, are the people satisfied with the factual basis?
People satisfied the court is sufficient factual basis for accepting the defendant's guilty pleas as to counts 1 and 3. Courts comply with court statute in doing so, and people are aware of those threats or promises, other instruments not placed on record.
Thank you, Mr. Kilo.
Satisfied the court is compliant with court rule or statute, and has a factual basis for each of those pleas.
Thank you. Mr. Stimmer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all charges. We'll set this matter for a sentencing hearing. Mr. Stimmer, you do have the right to have that hearing in person here in the courtroom in Otsego County. And if you want to exercise that right, the court would sign an order to have you transported here for that hearing. You can waive that right and we can have that hearing by video as we're doing today. Do you know how you'd like to
Yes,
proceed?
I'd rather do it by video if that's all right.
Okay, so the court will set this for. Okay, the court will set it for video sentencing hearing. Somebody from the probation department will be in touch with you for a pre-sentence report. Mr.
Okay.
Roll, anything further on this case today?
No, Judge, thank you.
Mr. Kilo?
Nothing further, thank you.
All right, thank you, Mr. Stimmer. That's all we have for this hearing today.
Okay, thank you, Your Honor. Have a good day.
Thank you. All right, Mr. Dussault, are you able to hear me okay?
Yes, sir.
All right, we're on the record in People versus Christopher Dussault, case number 236471. Mr. Dussault is present by video from Department of Corrections. I'd like to have counsel put your appearances on in this case.
Member of that people, Gary Gilo,
Set for a status conference in this case today. Mr. Kilo, can you tell me how we wanted to proceed in Mr. Dussault's file?
my understanding, we are here for sentencing on a misdemeanor.
Right, Judge. You don't have a PSI because the court waived the necessity of a PSI.
I see, okay, sorry. All right, so we don't have a pre-sentence report. Looks like Mr. Dussault pled to a misdemeanor receiving and concealing, is that correct?
Yes.
All right. Mr. Rolla, is there anything on behalf of the people for allocution?
Oh, Judge. Judge, this is, the defendant in this case was one of two passengers in a vehicle driven by Ms. Neerman. It's a situation where the facts as to the stolen property aren't in dispute. I leave sentencing to the discretion of the court.
Thank you, Mr. Kilo.
Right, Mr. Dussault's position right now, I'd ask the court just to assess fines and costs. Court fees.
Thank you. Mr. Dussault, is there anything that you wanted to state for sentencing today?
No, sir.
Mr. Dussault, what are you currently in Department of Corrections? What's your current out date, most earliest out date?
2031, September 22nd is 2031.
Okay. All right, Mr. Rolla, is there any restitution in this matter?
Judge, that's what I'm looking at right now. Give me a moment. That's what I'm trying to-
There's no rest.
There is no restitution
No
on this file. The chainsaw was returned to the owner.
Okay. All right, and we know how much jail credit Mr. Dussault is entitled to on this file.
He was in the Crawford County Jail, Judge, on other charges. And as of March 20th, 2023. So he wouldn't have been getting credit for that if he was there on those charges. He would, as to Otsego County offenses.
He would? Or
He would not, no, because he was held on different charges. I do see he was arrested, so he's obviously entitled to at least that.
Mr. Dussault, did you ever post bond on this file in Otsego County?
No, I was incarcerated in Crawford County.
So he wasn't out on bond, he shouldn't get credit, right?
Correct, Judge.
Since March. Date of arrest. He said. Since what date in March, Mr. Rolla?
I'll be back up, Judge. There's a lot of notes in this one. Here we go. Looks like. Rick from Crawford County Jail. Apparently he was there at least as of January 20th of 2023. More than that, I
I
can't
got
tell
to
you.
Crawford County on November 1st. It was November 1st at Crawford County Jail.
I have no reason to doubt that, Judge. I do know, just know that he was there in January.
All right, so, okay, Mr. Dussault, the court is simply going to sentence you to time served on this charge. So the court's not going to sentence you to any additional time. You've been lodged for at least almost 10 months on this charge. The maximum the court could impose would be up to 1 year. I recall your plea in this matter, and I understand the facts of this, how you came into possession of this chainsaw. And I don't think that the court needs to impose any additional jail time. So the court is going to sentence you to 10 months in the Otsego County Jail with credit for 10 months served. Court is going to require to impose a crime victims assessment of $130, state cost of $68, court costs of $325, and attorney fees of $350. Mr. Dussault, because this is a misdemeanor, there are no written appellate rights. If you wanted to seek an appeal of this sentence, you would need to file for that appeal within the next 21 days. Mr. Roll, anything further that we need to address on this file?
Not from the people, thank you.
Mr. Gilo.
Nothing further. Thank you.
Mr. Dussault, did you have any questions at all?
No, sir.
Okay. All right, thank you. That's all for this hearing today, and the court's going to disconnect at this time.
Thank you.
People versus Clark, case number 216098 and 226458. Ms. Clark, I'm going to have you come right up to the podium here, please. Record should reflect that Ms. Clark is present here in the courtroom today. This is the date time set for sentencing in this case. Ms. Clark, have you had a chance to go through the pre-sentence report and to talk to Mr. Kilo about that?
Well, Judge, in light of the fact that on Monday we received the prosecutor's sentence memorandum, the court received that.
I did.
I don't know what the court wants to do with that, but she's been accepted into drug court. And I don't know where the court's going to address that today or not.
Well, I mean, there are challenges to the scoring guidelines, so I think we would need to have argument and the court would need to make a decision.
Well,
Unless you're indicating you need.
She's in drug court. And Mr. Roller wants to kick her out of drug court. I'm going to ask for a 30-day adjournment for this month.
Mr. Rowland.
Judge, as I indicated, we didn't get the PSI until late Thursday night. I didn't even see it until Friday afternoon because I was in court. And then I filed the PSI, sent a copy to Mr. Gilo on Sunday, as a matter of fact, since I worked the entire weekend to get it done, and copies to the court. If the court wants to adjourn it for 30 days, obviously that's within your discretion. But Mr. Gilo's office was sent it. Since today is Wednesday, he could have filed a response for that time.
Well, I mean, these challenges to the scoring guidelines as to both files have a significant impact on the sentencing guidelines and what happens with Ms. Clark, because to the extent, especially with regard to the OB-19 challenge, it has a potential to take her out of community sanctions. And so, given the significance of the challenges, I think it's appropriate to allow Mr. Kilo an adequate opportunity to respond in writing. One thing I do want to clarify, Mr. Rolla, because the OB-19 challenge was based on the substances being taken into the jail. And my review of the file was that applied. You have it listed as applying under the 6098 file.
Correct.
But when I looked at the reports, it looks like that happened during the course of the facts under 6458.
I'll have to look at that, Judge. And again, it arose after the incident of the arrest, but was not discovered, as I understand it, until she was actually taken into the Galtaston County Jail. And that's where the remainder, like 7.6 grams, I believe, of methamphetamine was discovered.
Right, but what I'm saying is that occurred during a different arrest than the other challenges to OB 14 and 15.
And I'll look at that, Judge, and I'll address that. The court may very well be correct. Again, I was doing that at about 6 o'clock Sunday night.
Okay.
And because I wanted to get it to the court as quickly as possible.
All right, because it makes a difference which file it's in and whether or not it's granted. So the court will set this for a sentencing hearing in 30 days. Mr. Hilo, you can just file your written response to the challenges.
Thank you.
And Ms. Clark,
Yes.
you can keep going forward with drug court. Don't change anything about what you've been doing because you need to continue to comply with that. Okay. Okay. Ms. Clark, can you hold on for 1 second? I see Mr. Hamlin from drug court is connected. I just want to see if he's had some input into Ms. Clark's case. Mr. Hamlin, which case were you connecting in on?
Morning, Judge. It was just for Ms. Clark's case. I just wanted to be able to provide any information to the court if needed.
Okay, so we just addressed her files. As you may or may not be aware, Mr. Rolla has filed some challenges to the scoring and the guidelines, which would affect the range of Ms. Clark and has the potential to take her out of a community sanction range. So the court is granting an adjournment to allow her attorney, Mr. Hilo, to address challenges in writing because of the significance. So I don't know if you're aware of that, but that's how we're going to proceed today.
All right, Judge, I appreciate your time.
Was there any other input that you needed to give us while she's here?
You know, she's doing relatively well. She's got a long way to go, of course, but just trying to keep her mindset calm is where I'm trying to be at right now.
Okay, and I've instructed her that while we're waiting over the next 30 days, that she needs to continue to comply with all the drug court requirements.
Very good, thank you.
Ms. Clark, any questions at all?
Not today, yeah.
Okay, all right, thank you. Okay, thank you, Mr. Hamlin.
Thank you, Judge. Have a good day.
Can you tell me your name?
Laura Stickney.
Okay. People versus Stickney. Ms. Stickney, come on, right to the podium there. This is case number 216220. The record should reflect that Ms. Stickney is present here in the courtroom today. We're set for a sentencing hearing on a probation violation in this case. I did receive a violation report. Stickney, did you have a chance to review that and go through
No,
that?
I haven't. I've been incarcerated.
Okay. Do you want to have a chance to talk to Mr. Hilo about that this morning?
What's the
Under
time?
sentence. Ready to proceed.
Stickney, are you okay with going forward now?
Yes, sir.
Mr. Hilo, are there any changes that need to be made to that report?
No, Judge. Thank you.
Mr. Rolla or Mr. Rolla, any changes that need to be made to that report?
I don't believe so.
Ms. Davis or Mr. Rolla, anything that either of you wanted to say regarding the recommendation or sentence?
Your Honor, I just wanted to point out that this sentence includes dismissing the original bench warrant that was issued. And I don't have it in front of me. But I just want to make sure that that's addressed, dismissed with the sentence, Your Honor.
Okay, thank you. Mr. Kalo, anything on behalf of the stick?
In light of the recommendation, I have nothing to
Stickney, anything that you wanted to say today?
No, sir.
All right, I did have a chance to review the report prior to today's hearing. I also had a chance to review your file just to kind of familiarize myself with your circumstances and background in this case. And given the nature of the violations in this case and the recommendations, I do think it's appropriate. Court is going to follow the recommendations as presented here in this report. Number one, the court is going to discharge you unsuccessfully from your probation. In this case, the court is going to preserve any outstanding fines and costs. The court is going to also dismiss the bench warrant from, I believe it was August 12th of 2022, and not proceed further on that because you're already serving a sentence in Wexford as to that charge. The court is not going to impose any additional jail time as a result of violations in this case, other than just again to discharge you unsuccessfully from probation. You are entitled to 9 days of credit, so the court is going to impose 9 days jail credit for 9 days served. You do have the ability to appeal the sentence. We're going to provide you with some paperwork that explains what your appellate rights are, as well as how to request. We're going to help you with any appeal.
just the receipt.
Ms. Davis, is there anything else we need to address?
No.
Take these with you. For the record, Your Honor, my client signed the appellate rights and handed the same copy of the appellate rights. I'm handing the same to the court.
Thank you. That's all for today. All right, our next hearing is set for 10:30. We'll take a short recess. The court will come back on the record at 10:30.
10:45.
And Mr.
Police are at 10:30.
Yeah, but he's unrepresented. Not Okay, we're on the record in People versus Glazier, case number 236560. The record should reflect Mr. Glazier is present here in the courtroom today. Well, if you can put your appearance on.
Yes, sir. For the record, my phone behalf of the people.
All right, Mr. Glazier, you're appearing today without a lawyer, is that correct?
Yes, sir.
Go through a couple things with you in regard to that. You understand that you do have a lawyer, or you do have the right to have an attorney?
I do.
Okay, and if you couldn't afford one, you have the right to have one appointed for you at public expense.
Yes, sir.
And is it your wish to proceed today without a lawyer?
Yes, it is.
Okay. In the past, we've discussed the risks of proceeding on your own. And you understand, even though we're at sentencing now, there may be aspects of your case that a lawyer could help you with that could potentially result in different guidelines or a different result for you in terms of sentencing.
I do understand, sir.
And in spite of that continuing risk, do you wish to still represent yourself?
Yes, sir.
So we'll go forward today. Did you get a copy of that report?
I did.
Did you have a chance to review that?
I did look over it, yes, sir.
Okay. Is there any factual information in there that's incorrect?
Not that I was able to find.
Okay. And you understand that as part of sentencing, there's different variables that are scored by the department. Did you look at those?
Yes, sir.
Okay. And that's one of those things that's kind of a legal issue that a lawyer might be able to review for you and may have challenges to some of those variables. Again, you understand that without that kind of training or experience, you may not be in a position to be able to adequately do that.
Yes, sir.
You still wish to proceed without having a lawyer to help you with that?
I do.
Okay. All right. Is there anything about those variables that you wanted to challenge or that guideline range, which is 0 to 11?
No, sir.
Okay. Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections as to the body of the report, and no challenges to scoring the appear to be scored correctly.
Okay. Anything on behalf of the people for allocation?
Briefly, Judge, this is the second felony situation. It's 5 misdemeanor priors, including 2 drunk drivings and attempted RNO. It is a situation where people believe some jail time should be appropriate. I would further indicate that as required by statute, there are license sanctions under MCL 257-319 that will be imposed by the Secretary of State. Thank you, Judge.
Thank you. Mr. Glazier, was there anything that you wanted to say today?
Just, I'm remorseful of what I did. I mean, just shy of a year ago, I had 2 strokes, and with them trying to get my medications regulated and to go through a divorce. Meanwhile, I own a concrete company where I employ 6 employees. I'm remorseful and accept any and full responsibility for my actions. I just request that there would be some kind of way to work with myself to be able to keep my employees employed. For Mason to try to find work at this time of the year could be pretty difficult. Just, again, I understand what I did was embarrassing and completely wrong, but nonetheless, I did commit the crime. So with that being said, I don't have anything else.
And Judge, for the record, people have no objection to work releases the court finds appropriate.
Okay, thank you. Mr. Glazier, I did read through the report, so familiar with what happened in this case, as well as your background based on the information that was presented in that report. And, you know, I read what was going on with you at the time that this incident occurred, and I understand personal problems like that can lead people to do things that they might not otherwise do. Doesn't make it acceptable, and it doesn't relieve you of the responsibility and the consequences of that. But I'm hoping that those were the reasons why you did this at this time, and that those are things that you wouldn't repeat again in the future. The guidelines are 0 to 11. I think a jail sentence is appropriate, but I agree with Mr. Rolla Given your circumstances, I think participation in the work camp, which allow you to continue with your employment, running your business. That's kind of the reason why we have that program here. It still provides oversight and supervision for you, and you got to check in, all of those things, so that we can make sure you're doing what you should be doing over the next 90 days. But I don't think it's in the community's interest to not allow you to participate in that program. So the court is going to impose 90 days. In the Otsego County Jail, you have credit for 2 days served. The court doesn't have any objection to your immediate participation in the work camp program. The court is going to order a crime victims assessment of $130, a state cost of $68, court cost of $325, and a DNA testing fee of $60. You do have the ability to appeal this sentence, and Mr. Fire here is going to give you some papers that explain what your appellate rights are, as well as how to request a court appointed lawyer to help you with it. All right, have you received those papers, Mr. Clay? I have. Okay. So I'm noting for the jail, I don't have an objection to your immediate release to work camp. You do need to go with the officers now to be booked in. But you should be released to work camp as long as you don't. Thank you. I'll get to it. And Mr. Gila, are you ready on Mr. Fournier's case? Mr. Fournier, you can come over to the podium there, please. On the record in People versus Fournier, this is case number 236574 and 6575. The record should reflect Mr. Fournier is present here in the courtroom today. I could ask counsel for your appearance.
Yep. Your Honor, for the record, my phone down to see. Here you want to have Mr. Fournier.
This is the date and time set for sentencing in this matter. Mr. Fournier, have you had a chance to go through the pre-sentence report and talk to Mr. Gila about that?
I have. Oh, I went over it.
Do you need more time to do that?
No, sir.
Well, are there any additions, deletions, or corrections to that?
No, Your Honor, thank you.
Challenges to the scoring guidelines?
No, Your Honor.
Rolla, do people have any additions, deletions, or corrections?
So additions, deletions, or corrections to the body report or challenges as to scoring guidelines.
Anything on behalf of the people throughout?
A couple of things, Judge. First and foremost, I want to indicate for the record that I'm familiar with Mr. Fournier. I know his daughter for a very, very long time. I suspect she grew up with my daughters. I just indicate that for the record. And again, in this particular case, this is a situation with the defendants' 7th and 8th felonies, 8th and 9th drunk driving, 6th and 7th drunk driving thirds. The defendant's received drug court, he's received jail, he's gone to prison twice. I know because my office with the court sent him there last time. This is a situation where he has 6 low severity crimes, of which only 4 are taken into account by the sentencing guidelines, 29 misdemeanors, of which only 7 are taken into account under the sentencing guidelines. He doesn't qualify for boot camp, but he does qualify for the PA 511. That being said, perhaps now, for maybe the first time in a long time in Mr. Fournier's life, he is maybe finally addressing his substance abuse situation. I see that he went to the Lions Den, tried to go through the Lions Den program. And I would also indicate, because of what this court may sentence Mr. Fournier to, he's gonna miss perhaps his daughter's wedding. He already missed her high school graduation. And I know that weighs on her and has weighed on her. I don't know how it weighs on him. I hope he hears my voice when I say that. Under the circumstances, I'm happy with the recommendation that's given. And again, thank you.
Mr. Yulo.
My client, as the court adopt the recommendation, the client is interested in going through the lion's death. He has not had the time of, let's say, type of treatment ever that's even close to what the lion's den in fact produces. He would be he'd be in there for 8 to 12 in lion's den. A procedure, if you will, or he does really well, and then it falls off. It just can't seem to stop. And I think at the Lions Den, that those people would give him the tools to, for once in his life, be able to walk by alcohol and not have to consume it. So I'd ask the court to fashion a sentence along those lines.
Thank you. Mr. Fournier, anything you wanted to say?
Mr. Roll is absolutely right. I've been fighting with this my whole life. I've missed out a lot in my kids growing up. I've always been a dad, but I've never been a father. I accept everything that I've ever done. I've never denied the fact. I did, in fact, do everything in my power to try and do the right thing. It's not something I want in my life. I have grandchildren now, as Mr. Roll stated. Beautiful adult children that are doing really, really well despite what they see me do my whole life. I don't want my grandchildren growing up. I don't want my children missing any more out of me. I would gratefully like the opportunity to be able to, I know in my jail term, and then be able to go through this program. I called all around the state of Michigan. This was the only one that offered what it did, not just a spin dry, get you out of here and send you on your way and make it look good for whoever's foot the bill for it. This one has no bill. This one has everything to do with me. Growing tighter to my family, growing tighter to this community. And the sport groups in my backyard.
All right, I reviewed the report, so I'm familiar with what's the circumstances that lead you before the court in both of these cases. Certainly concerning your continuing to operate vehicles while under the influence, even when you're on bond for one charge. And you in these cases and in past cases, you present a significant danger to the community because you continue to engage in the same activity over and over again. And it's not just alcohol. I mean, I fully understand alcoholism and how difficult that can be to overcome. But you're adding getting in the car and driving around to that. There's no reason why those two need to be combined if you're having a problem with the alcohol. Get that, but you're endangering yourself and you're endangering everybody else in this community, and your record is bad. I mean, 13 jail sentences, 3 prison sentences, you've been on probation 13 times. At some point, the court has to consider just the punishment aspect of this, because it doesn't make sense to continue to do the same thing over and over again when it just results in danger to everybody else from you being on probation. That's really my concern at this point. And Mr. DeLeo, who wrote this report, indicated that there's two ways the court could go. And there's the rehabilitation aspect, and then there's just, we just need to get you out of circulation so that people aren't put in danger. And unfortunately, given your past history and your behavior in these two cases, which again, this could call for consecutive sentencing because you were on bond at the time you committed the second crime. I'm not going to impose consecutive sentencing in this case, but I think based solely on the safety of the community, I don't feel like I have any confidence that if I put you on probation, that sometime during that term of probation, you're going to relapse, you're going to get in a car, you're going to drive and kill yourself or kill somebody else or seriously injure them. And based on the number of past offenses, based on the number of previous times that we've tried probation, I don't see any value in taking that risk at this point, putting other people's lives in danger at this point, given your history. So I find that it's in the community's interest and necessary for the safety of the community to impose a prison sentence as to both of these files. And I'm not going to make them consecutive, but I think based on your conduct in these cases and your past history, it warrants a sentence at the top end of the guidelines. Court is going to sentence you to 34 months to 10 years in the Michigan Department of Corrections as to file 236574. You have credit for 96 days served, or it's going to impose $130 crime victims assessment, state cost of $68, court cost of $325, attorney fees of $350. That's to file 236575. The court is going to sentence you to 34 months to 10 years in the Michigan Department of Corrections as to that file, 94 days credit, $68 state cost, and a crime victim assessment of $130. You have the ability to appeal both of these sentences, and Mr. Thiel will provide those appellate rights to Mr. Warner.
Record, Your Honor, my client signed both of his receipts of appellate rights in each case. That,
Primary, your Army commanded. Right, you have the facility connected to Mr. Chesher. I don't think they have. Mr. Chesher, can you hear me?
Yes.
All right, for some reason, the camera is not on in your location. I don't know if there's an officer there that can help you with that.
Me a second. Yes. Just 1 second, there's an officer coming.
All right, thank you.
It's showing us right there. Can you see us?
We cannot see you. I can hear you good.
Because I can see you guys and I can see us on our end.
Okay. All right, Mr. Chesher, do you have any?
Oh, gee. All right, let's see from here. And then go up there. So. Oh. You know, I'm never up here enough to know enough about this one. Hey, Fleischer. All right, I just talked to the room and he said, we can see you guys, I can see us on our camera down here, so he thinks it's on your end.
Okay, that's fine. We can proceed. Mr. Chesher, are you ready to go forward with the hearing today?
Yes.
Okay. All right, we're on the record in People versus Chesher. This is case number 236555. The record should reflect that Mr. Chesher is present today by video from Department of Corrections. If I could have counsel put your appearances on.
For the record, gentlemen, I call the Harry Deal on behalf of Mr. Chesher.
This is the date and time set for sentencing hearing as to this file. Mr. Chesher, have you had an opportunity to go through the pre-sentence report and talk to Mr. Gillo about that?
Yes.
And Mr. Gillo, are there any additions, deletions, or corrections that need to be made to the report?
No, Your Honor.
Are there any challenges to the guidelines as for?
No challenge with that.
Thank you. Mr. Rowland, do the people have any additions, deletions?
Additions, corrections, and challenges.
Anything on behalf of the people for allocution?
Yes, Judge, thank you. As the court's well aware, in looking at the PSIR, I'm sure the court has noted this prior record, which indicates that this defendant has already seriously injured others by drinking and driving. His current offense simply indicates the people's position without significant court intervention at this time. This threat to the community will simply continue unabated. It's worth noting that sentencing guidelines only account for 4 of his 6 prior felonies, 8 of his prior 24 misdemeanors. Guideline range is 12 to 30 up to 7.5 years. And in this particular case, as the court took notice in the last case, this is one where perhaps the court should look specifically at the higher end of the guidelines in imposing sentence, along with the funds, costs, and other matters. Thank you, Your Honor.
Thank you. Mr. Kilo, anything on behalf of Mr. Cheshire today?
Yes, Judge, looking at the recommendation and the fact that he's going to be served as consecutive, I ask the court to consider something in the middle of
Thank you. Mr. Cheshire, was there anything you wanted to, excuse me, state for purposes of sentencing today?
Yes, I'd like to just let you know that I've been struggling with alcohol for most of my life, and my entire criminal record is based off alcohol. I've never even had a speeding ticket sober. I worked real hard at my sobriety and to change everything about my life the last time I was in prison, and was released November 9th and left Marquette Branch Prison to go to Helen DeVos in Grand Rapids, and took my son off of life support and kind of got off track on my sobriety and basically everything else in my life. And this has been another wake-up call. I'm just very that I wasn't in another car accident and nobody got hurt this time. And it's been basically a blessing in disguise, for lack of a better term. Yeah. That's all I got. Thank you.
All right, thank you. I did have a chance to review the pre-sentence report in this case, and that contains a lot of information about what happened in this particular matter that brings you before the court today. There's also a lot of information, of course, about your background and your history, Mr. Cheshire, and I agree. I mean, it's all related, or mostly related to alcohol use, and I understand that that's a difficult hurdle to overcome, and it can take a lot of failures before you have success. My concern is how those failures affect other people in the community, innocent people who you encounter when you're under the influence and operating a motor vehicle, and putting in people in danger of being injured or killed, putting yourself in that kind of danger, people that you have in your vehicle with you. And looking at your past history, which of course leads to some of the higher end of the guidelines that you have now. 12 prior jail sentences, 5 prior terms on probation, 2 prior prison sentences, and lots of misdemeanors and felonies are related. All of those things, Mr. Cheshire convinced the court that a prison sentence is warranted in this case based on your behavior here, and in particular in relation to your past history as well. The court finds that an appropriate sentence is one at the top of the guidelines given that past history and your continued behavior in putting others at danger through driving while under the influence. And the court has a responsibility to try and issue sentences that are going to result in eliminating those kind of dangers to the community. The court is going to sentence you to 30 months to 7.5 years in the Michigan Department of Corrections. Because you were on parole at the time of this offense, you are not entitled to any jail credit. And the sentence must be consecutive to any sanction for violating your parole. You do have the ability to appeal this sentence. If you haven't already received it, the court will provide you with some paperwork that explain what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Rolla, is there anything further that we need to address on this file today?
Judge, there's the $50 state cost just to count 2 driving licenses.
I'm sorry, I did fail to impose the fines and costs. The court is required to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, restitution in the amount of $250 payable to the Otsego County Clerk to be dispersed to the Gaylord Police Department. That's as to count 1. As to count 2, a $50 state cost, or court is not going to impose a fine. Mr. Chesher, you are remanded to the custody of the state at this time. That concludes our hearing, and the court is going to disconnect at this time.
Okay.
Our next hearing is set for the team of Ms. Medina. We'll take a short recess until 11:15. On the record in People versus Medina, case number 226278. Counsel for the
Brown on behalf of Ms. Medina.
set for a sentencing hearing at 11:15.
Yes, she's here.
Ms. Medina, if I can have you come up to the podium there, please. This is the date and time set for sentencing in this matter. Ms. Medina, you had a chance to go through the pre-sentence report and talk to Mr. Brown about that.
Briefly,
Do you need more time to do that before we move forward? Okay.
if you wouldn't mind, more.
Mr. Brown, you can take a couple minutes and talk to Ms. Medina. So you go ahead and do that.
Thank you.
Now. Mr. Trush, is Mr. Asbury ready to go? Mr. Asbury, if you can come up to the podium, please. We're on the record. Versus case of Asbury, case number 226329. Reflect Mr. Asbury present here in the courtroom today. If I could have counsel for the
Anna Brooker, period, we got the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Asbury.
This is the date and time set for sentencing in this matter. Mr. Asbury, have you had a chance to go through the report with Mr. Trush? Yes, sir. Mr. Trush, are there any additions, deletions, or corrections to that report?
Not from the defense.
Okay. Are there any challenges to the guidelines of this court?
No, Your Honor.
Do people have any additions, deletions, or corrections?
One correction, Your Honor, page 2, 136 days credit. I believe that should be 0 because he was on parole.
Mr. Trush?
So, Your Honor, I was aware of this issue coming into this. I was surprised actually to see that they had given him jail credit to begin with. As I dive deeper into this, though, I think that he resolved his parole issue separate from this and has served a sentence for that. And under those circumstances, I think he would be entitled to credit on it.
I'm not sure that makes a difference.
Well, I mean, if I may, obviously, if this sentence is served consecutive to the parole sentence and he's already served the parole sentence, he would be entitled to credit. Right? I mean, the whole point of him not getting credit is that it's mandatory consecutive sentencing. So if he's already served and resolved that matter, it's not mandatory. I mean, there's no consecutive sentencing issue.
Davis?
I can explain.
Okay.
He is entitled to 0 jail credit. We do reflect the 430. I'm sorry. The 436 is reflected because that is placed on the unexpired portion of what he's on parole for. If he was to get returned to prison or if it was to be consecutive. However, the statute mandates that there's 0 jail credit at that time. So 0 jail credit.
All right, so I guess the way to resolve this for today's purposes, Mr. Trush, I'm gonna leave the jail credit issue open. I'm gonna ask that you file a motion for jail credit. Submit whatever legal authority that you have for why the court should grant or is even allowed to grant jail credit for that time. And Ms. Brugger, if you want to file a response brief, we'll have a hearing and then I'll make a decision as to whether statutorily I can even give him credit. And if I can, what that credit should be. So
Understood.
I'll hold that issue in abeyance because that's obviously a significant amount of time in this case. And I think certainly Mr. Asbury, to the extent he has an argument that he's entitled to that, should have an opportunity for you to brief that and present that. Okay, aside from the jail credit, Ms. Bruker, any other changes?
No other corrections, Your Honor, and no objection to the scoring.
All right, Ms. Bruker, anything on behalf of the people for allocation today?
Just briefly, Your Honor, I have reviewed the ESI and the attached statements as well. NPOC is recommending a sentence of 5 years to 20 years, and also fines and costs of that. One of the things I would just highlight for the court again, and I'm taking a look at Mr. Asbury's statements when I make this comment. This isn't just a possession case. This is a delivery case, essentially a drug trafficking case. Mr. Asbury has a somewhat lengthy history involving substance abuse or substance use convictions. Prior to April of 2023, he had not availed himself of treatment since 2016. They were trafficking approximately, I think, 48 grams of methamphetamine to northern Michigan at the time that he was apprehended. He was on parole for a drug-related conviction at that time. He's had numerous opportunities that he wanted to turn things around, but instead he continued to participate in illegal activity and to bring these substances up north. So I believe the recommendation is appropriate, and I would ask the court to follow it.
Thank you, Mr. Church.
Thank you, Your Honor. Obviously, the court's had an opportunity to review some of the letters. I would indicate, this is a unique case, and it's unique because of the amount of time that Mr. Asbury spent in jail prior to, the plea and the sentencing. It's unique in that there was a lot of negotiations that happened during this case. Because Mr. Asbury was in jail, he was somewhat limited in some of the things he can do. He did repeatedly express a desire to engage in treatment. He even secured a position, a spot, if you will, in a drug treatment court. Ultimately, we weren't able to effectuate that as part of the deal because of what his guidelines are. There would have to be an agreement from the prosecutor for him to be, even for the court to be able to sentence him to that. But I bring these things up because, again, he did make efforts to engage in those things. He's identified to me that he wants to make changes. He even as we were working through when he was released through the plea and leading up to sentencing, he continued to maintain contact with that drug court. We continued to try to work on that, but it wasn't something that materialized there for him. But it wasn't for lack of effort, and I think that's important because it shows a desire and a willingness and a follow through to make those changes. And the counterpoint to that, I'm sure the court is aware, is obviously he knew he had these cases pending. The court's also aware we have lots of defendants who have cases pending and don't do anything. So I do think it does show something that he made those efforts. And I just ask the court to follow the agreement.
Thank you. Mr. Asbury, anything that you wanted to say today?
The 6 months that I was just out, I got my children, my 3 daughters, were back in my life, and I feel embarrassed and I regret everything I did, like I gotta be ripped out of their lives again, and it's the worst thing to do. I just apologize.
All right. I did review the report and all the attached documentation, so I'm familiar with your circumstances, your background, certainly the circumstances that bring you before the court here today. There's no question that substance abuse has played a role in your history and your prior offenses, and to the extent that you've undertaken some actions to try and address that, that's only going to be beneficial to you going forward. More concerning to me about this case on behalf of this community is not necessarily your own substance use disorder, but your role in bringing large amounts of those substances to this community. We are talking about a significant amount of methamphetamine. And that is conduct that the court has an interest in discouraging, not only to punish you and prevent you from engaging in this conduct again, but so that other people who are considering engaging in this understand that if they're caught, there are significant consequences to it. Your guidelines in this case do call for, at a minimum, a prison sentence based on the agreement between the parties as to the sentencing cap. I think that's an appropriate agreement. I think it adequately accounts for your conduct in this case. I think it helps to accomplish those goals, not only of punishing you, but of deterring and preventing others from engaging in this kind of conduct. The court is going to follow that agreement of the parties. The court is going to sentence you to the Michigan Department of Corrections for a period of 60 months to 20 years. You do have credit for 0 days served at this point, but of course, the court is going to preserve that for the decision later once Mr. Trush files a motion with regards to that. A $68 state cost of crime victims assessment of $130 and court costs of $325. You have the ability to appeal this sentence, Mr. Trush, if you can provide Mr. Asbury with his appellate rights and let me know once he's acknowledged receipt of those.
Your Honor, I am rendering both initial notice of appellate rights.
Asbury, you are remanded to the custody. All right, Mr. Brown, are you ready with Ms. Medina's case?
Yes, Your Honor.
All right, go back on the record in People versus Medina. And once again, the record should reflect Ms. Medina's present here in the courtroom. Medina, have you had a chance now to adequately go through that?
Yes, Your Honor.
All right. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, no changes.
Ms. Bruger, any additions, deletions, or corrections?
No, Your Honor, no challenges to the scoring.
Thank you. Anything on behalf of the people for allocution today?
Your Honor, the MDOC is recommending the sentence within the guidelines, which are 57 to 90 months plus court costs. One thing I would request that I don't think is in the recommendation for forfeiture of the taser that was seized. That was something maybe we could heard. Similarly, my comments, I just echo my comments that I made Mr. Asbury, that this isn't just a possession case or a use case. And I reviewed the witness, or I'm sorry, the support statements that was provided to the court. And it's a different case than just a use or possession case. It is quite serious. They were trafficking a large amount of methamphetamine to northern Michigan. She has had some history from back in 2018, a possession of methamphetamine case. I know she's been participating in treatment, but nonetheless, the actions of trafficking that amount of drugs is quite harmful to the community. I agree with the sentence of the guidelines. I would ask that the court sentence her to the bottom end of the guidelines, so it's sort of on parity with what Mr. Asbury received as a sentence. That's all I have.
Thank you, Mr. Brown. And just so, Mr. Brown, so you and Mr. Medina are aware, I did receive the support letters that were submitted on her behalf. There were a number of those, and I had a chance to review all of those prior to the hearing today.
Thank you.
Anything for allocution, Mr. Brown?
Yes, Your Honor. Ms. Benita stands before you clearly still a very young lady. She does have a work record the history of employment. She has been through some treatment, outpatient treatment. This is a devastating thing here. She has 3 children. She grew up in what appears to be a good family home. For whatever reason, sometimes teenage rebellion, sometimes it's just hanging out with the wrong crowd. She got into methamphetamine and drug use. And it has taken a huge toll, which that's the reason she's here now. She's under no delusion that she is going to be punished for this. But I would ask the court to look at some of the good points here as well. It is mentioned in the PSI here that it's been a year after her arrest. I don't think there's been any violations. And it's written that the defendant may be truthful standing before your honor, stating that she is a changed woman. Unfortunately, it took something this devastating to change her. I don't have personal experience with methamphetamine, but I have represented numerous people that do, and it still astounds me the impact and the control that it can have over a person. But she is not a lost cause here at this point. She has every reason in the world to use this time to really contemplate, really better herself, which I believe she will do that. And something very, very important to look forward to when she gets out, which is a return to her family and raising her children. I would ask the court to take those things into consideration when forming a sentence here. And I would ask the court to look at sentencing her to the bottom of the guidelines. She has a prepared statement as well.
Ms. Medina, anything that you wanted to say today?
Yes, it's, first, Your Honor, I would just like to, say that I deeply regret my actions and I take full responsibility. Since I've been founded out from the jail, I have been on probation and have no violations. I have made many changes in my life. I see my children regularly, and they currently are with their father, who on a whole nother level is mentally and physically abusive, was mentally and physically abusive to me. And I feel like my children are dealing with that currently. And I know it puts a very large toll on my mother and father who are here with me today. And that's one of my biggest concerns, but I just want to take full responsibility for my actions on that day. I have changed. I do feel like I am doing positive things in society, and I go to meetings and I help people and I reach out, and I make totally different choices in my actions than I used to today. I do volunteer work as much as I can. And just again, just the time I've been out has been very stressful. Just knowing that this day is coming soon, and my children have to miss me again. But now it's I just hope this demonstrates that you have consequences, not just to my children, but to others. And I'm just ready to move on and get this part of my life over with.
All right, thank you. I did read through the report. I'm familiar with the circumstances, as you're aware, Mr. Asbury, part of this as well. And so through the course of this matter and yours, had an opportunity to become familiar with the facts here. As I said, I also read through the report, so I have information about you and your background in addition to what happened in this particular circumstance. I had a chance to review the letters that were submitted on your behalf. And I think you do have the potential for a positive future once this is past you. Sounds like you're a good worker, you're a valued employee. Sounds like you have the ability to make a lot of positive contributions. And both through employment, community, and in your own personal life. But there is a consequence to your actions in this case. And as I indicated with Mr. Asbury, the concern here is not only your own use, your struggles with methamphetamine and other substances, it's your role in making those available to other people in the community and exposing other people and making this something that can affect other people's lives too. And that's where the real problem comes in. That's why the law provides for such significant penalties, because it is such a harmful behavior to engage in. I think given the mitigating factors in this case, I agree with the lawyers that a sentence at the bottom end of the guidelines would adequately account for the wrongfulness of your conduct in this case, but also recognizing the mitigating factors. And the guidelines call for a sentence of up to 95 months. Again, mitigating factors in your past history warrant a sentence at the bottom end of the guidelines of 57 months instead of the 95 months. The court is going to send to the Michigan Department of Corrections for a period of 57 months. It's 57 months to 20 years. You do have credit for 90 days served. State cost of $68, a crime victim's assessment of $130, court costs of $325, and attorney fees of $350. As suggested by Ms. Bruker, the court will also order forfeiture of the taser that was at issue in this case. You do have the ability to seek an appeal of this sentence, and Mr. Brown, have you provided those appellate rights to Ms.?
I have, Your Honor. She has acknowledged receipt, and I'm tendering that acknowledgement.
Thank you. At this time, Ms. Medina, you are remanded to the custody of the state.
If you want. Where's that? We'll go. Just put it in. Yep.
We have Mr. Wilson present. Ashton. Mr. Roll, have you had contact with either the defense counsel? We had two other 11:30s. It's now 11:48. Assuming they aren't hearing today. I have People versus Wilson with Mr. Flagstaff. And
For the Wilson matter, Your Honor, I told you people, there's been no contact. Back when I came in this morning, asked whether or not Ms. Davis was aware of circumstances, and she didn't have any additional information to provide our office either. I don't know, I can't say where Mr. Flagstaff is. I have no idea. He hasn't had communications with our office. I see no notes in the file on Mr. Wilson's matter since September 1st, 2022. That was at the time of his previous sentence.
All right, I think that's probably an error. Mr. Claxton's listed, he probably previously represented Mr. Wilson. That's an arraignment on alleged violation.
That's my understanding, Judge.
So no problem with Mr. Claxton not being here. Mr. Wilson's not present though, and we're well past the time. So Ms. Davis, if you can, is that one of your cases?
It's not.
With,
It's Agent DeLeo, and I don't have the file even. I've looked and I don't even see a violation. It is listed in the court computer, but.
I signed a show cause for, oh, here, Mr. DeLeo on August 28th. So if you could just ask Mr. DeLeo to prepare a bench warrant and add to the violations that you listed, add a failure to appear to it for today.
And Agent DeLeo just responded that this was supposed to be by Zoom. Is there anybody, nobody?
No. No, Mr. Wilson has not appeared remotely or in person today. And Ms. Ashton, have you had any contact with Mr. Daly? Mr. Bowman, Ms. Ashton?
I'm checking on that now, Judge.
That was set by Zoom as well, but I don't see either her or her counsel present in the Zoom right now.
And I'm aware that they had specifically requested to appear by Zoom. I do see notes to that effect.
That's fine. I'm just gonna set it for a show cause plea hearing at the court's next date. I'm gonna set that for in person.
Judge, I would indicate for the record that when we were here last before the court on August 9th, specifically at the request of the defendant's counsel, this matter was adjourned to allow them 30 days to file a motion.
Okay, so we'll set it for an in-person hearing and show cause at the court's next available date.
Very good, thank you.
Thank you.
That would then conclude the court's morning document.
Concludes the court's morning docket. The court will be